Can
So the
he's here too, Your Honor.
was addressed in Lake.
Right.
They put him on the list for the staff.
But why is there?
He's out on bond and it wasn't addressed in the other county.
Oh, we're gonna address it today.
Right.
Thank you.
So just you have his criminal history.
Because I reviewed that. All right.
Yeah.
Sir, please tell me your name.
James Reed.
All right. It looks like you might be here in case number 21MM760AO, and or you have an out on bond case, which is 20 CF 11369AO. Your attorney is here. Let's see if you can shed some light on this paperwork that we've all been a little confused about. Go ahead, Counselor.
Thank you, Judge. Steve Wolverton for James Reed. Judge, on the existing case that Mr. Reed has, it's a felony case, charged as a resisting with violence case. I already represent Mr. Reed on that case. He was out on bond on that case. We've actually applied for and been accepted for the pretrial diversion program in that case, and we had a contract signing scheduled for February 18th. Mr. Reed was arrested on this matter over in Lake County on this warrant. My understanding was that he went to court in Lake County. And I will let the court know he was arrested for a misdemeanor DUI in Lake County. They served the warrant on him from Orange County. My understanding was the Lake County judge did set a bond on this Orange County warrant. However, when he was transported over here, it was then set back to no bond. I've not been able to verify that, Judge, so I'm just saying that's what I was told. However, he's back over here on the misdemeanor domestic violence warrant. That appears to be the only thing that is holding Mr. Reed at this time. So that is what we would like to address with the court. And there is, I apologize, the court did, or the jail did place, I believe, a detainer on him to reference the existing case that he was out on bond on. So we'd like to address that as well.
All right, I see. So there was a warrant issued for your arrest for battery domestic violence. So another judge has already found probable cause in this case. I don't have anything from Lake County. Do you know, well, I don't know if any conditions were set on that bond.
I don't, as of now, Judge, I think he's no bond on that misdemeanor DV, is my understanding at this time. And I would let the court know that the alleged victim from the domestic violence case is present in the witness booth, and he's the one that's retained me to represent Mr. Reed in this matter, and he's indicated to me that the allegations are overblown and he does not want to proceed.
All right, sir, do you wish to testify this morning?
Yes, that's fine.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you.
Does the state wish to inquire or the defense?
Yes. Can you tell me your name?
Gregory Alexander?
And Mr. Alexander, are you afraid of Mr. Reed?
No, not at all.
Has anything like this happened in the past?
No.
I'm sorry?
No.
Yes? Or you said no?
No.
No, okay, I'm sorry.
Sorry, it's really difficult to, yeah, get really close to the microphone.
Okay.
Yeah, just get close to the microphone. Thank
Sorry.
you.
It's hard to hear too, just so you know. So.
Okay. Were drugs or alcohol related to this incident?
Yes.
If something happened in the future, would you feel comfortable in calling the police or 911?
Would I feel comfortable calling
Yes.
the police? Yes, I could call them if I needed to, yes.
No further questions, Your Honor.
Does the defense wish to inquire?
Mr. Alexander, do you want these charges prosecuted against Mr. Reed?
No, I'd like them to be dropped.
Do you want to have contact with Mr. Reed?
Yes.
Do you want Mr. Reed to come home and live with you again?
Yes, absolutely.
And if you could tell the court what your relationship with Mr. Reed is.
He's my domestic partner and also my business partner as well.
I couldn't hear the first thing you said. He's your...
My domestic partner and my business partner as well.
You said domestic and business partners.
Correct.
And Mr. Reed is employed
Yes.
and has been employed steadily throughout the time that you've known him?
Yes.
Okay. And has Mr. Reed indicated his desire to seek treatment for alcohol?
Yes, we were looking into the Aspire system in order to place him as soon as he leaves.
Can you speak up a little bit?
Yes, we were looking at the Aspire program to put him into,
Very
so that
good.
as soon as he leaves, he
I
can
don't have any
start.
further questions, Judge.
Your Honor,
Just argument.
state has no objection to setting a bond, no hostile contact, no weapons, no firearms, no drugs, no alcohol. I see that the defendant is out on bond on the 20 CF 1369. And although it was referred to PTD, I'm going to pretty much confirm that this is going to kick him out of PTD, this arrest. And so he'll have to resolve that case another way. I don't object to taking no action on the out on bond case, but just for he understand that he's going to get kicked out of PTD.
All right, Counselor, any other argument?
It just, we have no objection to the conditions suggested by the state and just ask for a cash surety bond in this case not to exceed $1,000 and ask that the court take no action on the existing case that he's out on bond already on.
Counselor, I have to tell you that I'm inclined to revoke his bond on his out on bond case because that's a crime of violence and this is also a crime of violence. And based on the testimony today, there was alcohol involved and I think you said he was arrested for a DUI in Lake County, so it seems to be a pattern. Is there any argument you can provide this court why I shouldn't revoke his out on bond case?
Yes, thank you, Judge, for the opportunity. I can tell the court the charge that he's already out on bond on, and I know the courts don't like to hear factual allegations. I can tell the court pretty much everything in that case is on video. And it was an argumentative situation between the officers, but in my assessment, and I think the state's assessment as well, it's more of a misdemeanor situation than a felony situation as far as the violence is concerned. He's got absolutely no prior record at all. He had no incidents with the law enforcement until that arrest on that resisting case that he's out on. And obviously he qualifies for diversion. So I don't think, obviously he's not gonna be able to do diversion, but that was something that I think that we're going to be able to resolve, and my inclination is we'll probably be able to resolve that with a misdemeanor. This case here, I don't anticipate that the state's going to file charges on, given Mr. Alexander's testimony. And even in the warrant, the affidavit of the warrant, and you read on this case, is that Mr. Reed and Mr. Alexander returned back home. There was an argument in the car and pushing and shoving in the car. Then Mr. Reed went inside and went to bed and was laying in bed trying to go to sleep, and it was Mr. Alexander came in and started in on Mr. Reed and tried to remove Mr. Reed from the bed. And then that started another altercation, which then prompted Mr. Alexander to call the police. So in this situation, it was Mr. Reed who had removed himself from the argument, was in bed, and was trying to go to sleep. The DUI in Lake County, it is a DUI. Certainly it is his first in Lake County. We haven't been in touch with the prosecutors over there, but I do anticipate that we'll be able to resolve that at worst with probation and counseling. So I would suggest to the court that we put strict conditions on Mr. Reed, because the underlying issues here, he's 30 years old, he's got a bachelor's degree, he does he works as a property manager, he's got 60 properties under his supervision. He's an accomplished young man. Lately, he's had a real problem with alcohol. And I think there's some options for the court, certainly no alcohol as a condition of probation. The court can order that he receive a substance abuse evaluation, any treatment if they recommend any, which he's already indicated to me that he is willing to do. The court could impose or could order that he wear a scram monitor that detects alcohol the second he drinks any, and would alert the court if there's any violations there. So I think there's enough that we can do to ensure the court that he's not going to be drinking alcohol, and therefore he's going to be back to being a productive member of the community, as opposed to just warehousing him in the jail, which is probably just going to be, for a period of weeks or months until I think these charges would ultimately either be dismissed or resolved with misdemeanors. So I think it's appropriate. The state doesn't have a problem with keeping him out, and I would tell the court that if the court does just allow him to remain out on bond on the existing case, then certainly the division attorney at the state attorney's office is going to see this and is going to review it. And if they feel it's appropriate to revoke his bond, then certainly they'll file that motion, and then we'll litigate that in front of the division judge that's got all the facts in front of it, and we'll have a full hearing on that. So I think the state's interests are protected if the court allows him a bond. I think we can be productive with Mr. Reed. I think we can get him the help that he needs, and I do believe that these cases are going to resolve hopefully in the near future. So we'd ask the court to reconsider its position and grant Mr. Reed a bond on all cases, and even add those extra conditions on the one that he's already out on. Thank you, Judge.
All right, thank you, sir. I appreciate your argument. I'll tell you that my still major concern is, based on counsel's representation, that he has no criminal history, and I'm believing you, I'm taking you at your word on that he has no criminal history. In the last 2 months, he appears to have gone on a pretty steep downward spiral. from battering law enforcement to battering a partner. There's an allegation that there was a shotgun involved in this. Is the shotgun still in the home?
No, Your Honor.
Where is it?
It was my weapons, but
Right,
no.
but where is it?
I gave it to the officers.
You gave it to the officers?
Yes.
And I would note that in the report, it indicates that it was unloaded and he would use it to break property, not to.
Right, that
threaten
he didn't
destruction.
point it at the victim.
Yes.
Correct.
Nonetheless, if this is just an alcohol problem, it's a fairly serious alcohol problem that seems to have escalated rather quickly in 2 months. Battering law enforcement, battering a partner, at least grabbing a shotgun, which that's pretty significant because I'm sure there were other items in the house he could use to break things, although that's not acceptable behavior either. So that's my concern.
Judge, if I may, the program that we're looking at is Aspire. And I like the program. I've had good success with my clients there. And I've just had a client over in Brevard County apply for their program. Aspire, at least in Brevard County, and I imagine it's the same here, will not come to the jail to do interviews right now. It's going to be required that he's going to have to set an appointment and go to them and then do the intake interview and then do whatever program they recommend. So he's committed to doing that, and I think pretty much any program that we're going to be able to get into is going to probably have the same requirement that he schedule an appointment and go see them. So we would like to get him somewhere because I do agree with the court these last couple of months, you know, someone that's 30 with no history and all of a sudden he's drinking like this and getting into trouble. I think we need to address that. Being out in his support system with the professionals at a certified program, I think is the way to go to help him. And I think it would also be a big step towards resolving all these cases as well, instead of just letting them sit here and then starting over in a month or two whenever he's able to be released or longer.
Has he only been in jail for 3 days?
He was picked up in Lake County, I believe, day before yesterday. Is that correct?
On the 31st.
On
the 31st.
So actually, he's been, today's
All right.
report has been about 4 or 5 days.
In my experience, sir, rehabilitation programs only work when someone's hit rock bottom. I'm not convinced that 5 days in jail is rock bottom. However, based on the testimony here today and the representations and arguments by your counsel, I will take no action on your out on bond case, so I'm not going to revoke your bond. I'm going to set your bond in the current case at $1,000, special conditions. You're allowed to have peaceful contact, no hostile contact. Do you understand what that means?
Yes, ma'am. Somebody explained it to me, but I'd be more than happy to hear it again.
Okay, you can't even raise your voice,
Okay.
so you understand.
Yes, ma'am.
I'm going to allow that contact only. You're not allowed to possess a weapon, firearm, or ammunition. You're not allowed to drink or possess any alcohol. Yes.
I have a question, Your Honor. Did you see something in the paperwork where he was already brought in front of a first appearance judge in Lake County? Didn't you see a judge in Lake
I
County?
mentioned earlier, Judge, that what I was told is that he did appear before a Lake County judge on this, and the judge in Lake County had set a bond. However,
For
when he got over
$2,000.
here,
Yes,
it
I
was not
see that.
honored.
Okay.
So I think it would require this court to go ahead and readdress it at this point.
So I am. All right. I'm going to order that you maintain a separate residence. Sir, I appreciate you coming in and I appreciate your testimony here today, but I think there needs to be more time cooling off. I understand this is part of your support community, and like I said, you can have peaceful contact, but I will order you to maintain a separate residence. Do you have items there you need to gather?
No, ma'am. I can go straight to my mom's house.
Okay, all right, then at this time, you'll have to maintain a separate residence. Your attorney can file a motion in front of the trial court and they can modify that, but I think for now, we'll do that.
Yes, ma'am.
Do we have alcohol monitors that we can order?
You can do random urinalysis without him having to be on pretrial release.
So I can do that?
Yes.
All right, so I'm gonna order that. Remember I said you can't possess or consume alcohol, and I'm also gonna order random urinalysis screens, so you'll be tested to make sure that you're not drinking. Do you understand?
Yes, ma'am. Yes, Your Honor.
All right. Madam Prosecutor, is there anything I forgot?
No, Your Honor.
All right, good luck, sir. Thank you, sir, for coming. I appreciate it. Thank you, Counselor.
Thank you.
Thank you, Your Honor.
You probably really
have to list a start date for the random drug testing or no?
No.
No.
They're gonna have you go to courtroom too to get out.
What's next?
Maybe excused, Your Honor?
I'm sorry?
Maybe excused?
Yes, thank you so much.
Thank you, Judge.
For the fugitive unit, and then we'll go straight, the ones that you have in front of you.
So wait, what's the
Those are
fugitive unit one?
She has the paperwork over there.
Okay, what is that?
The waivers and complaints on fugitives that are held here for other states, would they sign their waivers of extradition to return?
So this is the first time we're doing that.
Yes, we do. I've done it with dedication before.
All right. What are we doing?
Okay, Madam Clerk?
Yes, please.
So what I have here is these
Really fun Thursday.
are defendants that sign their waivers. So it's a fugitive complaint that they're signing and remand on the waiver.
But he didn't appear.
He was here. They usually don't come in. We talk to them and tell them what their extradition options are from the sheriff's office. And they either agree to sign their waiver or they contest extradition and the other state has to get a governor's warrant.
Because it says personally appeared before me, the judge.
That's fine. They're here. You're more than welcome to have them. We've never done it before like that with Carter or anyone that preceded, but I mean, it's your decision.
Yeah, I think they have to come in here because I'm signing that they personally appeared before me. So I think I need them to come in. Sorry, it says they personally appeared before me, so I think they've got to personally appear. But you can just ask them. Since you've already talked to them, it's okay with me if you ask them and they agree on the record, and then I'll sign it.
Okay.
Sorry, y'all.
Are they available now?
Yeah, they're here.
Oh, they're here.
Yeah, they're already here.
What are those?
See, this one here, the fugitive is not here, the other states are trying to expedite, so.
We just gotta let that to them, know to bring them in.
Okay.
We don't have to stop.
Then that was easy.
Here, this gentleman had contested extradition and had been here for a while.
Okay.
California went ahead and did a governor's warrant, and in turn, the Florida governor issued the governor's warrant. He was served on that, so there's two orders that need to be signed. One is an order to dismiss the fugitive charge and effect service of the governor's warrant. And then the other one is a remand to California on the governor's warrant. And there's a deadline date for the court to furnish should the defendant want to file a writ of habeas corpus to challenge the governor's warrant before he can go to California.
Right, so he will not be released.
Correct. Unless California comes back and says that they don't want to extradite, and that's not the case at this point.
Yeah, this is a really serious charge, so they should extradite.
He showed me a piece of paper that I don't know was computer generated from the detective in California. Did something saying that the detective wasn't going to extradite.
I have a huge like just that code.
Choice is
Right
the
now.
prosecutor and the judge, and they've done that.
Who do you want first, Your Honor?
First I have, Jonathan Jones?
Jones?
Yes.
Jonathan.
This one?
Yes. You got it. And then he also has a local charge that he's here to resolve as well. So he can't physically be turned over to the authorities in Alabama until that's resolved.
Okay.
He has elected to sign the
Please tell me your name.
Jonathan Jones.
All right, Mr. Jones, you understand that you have charges pending in Alabama and also here in, it's Orange County, right?
Yes.
See, what I don't understand is how I got
Don't.
It's the same thing here in Orlando as the warrant for in Alabama. It's the same vehicle. I don't understand how they charge me twice for the same charge.
I don't know the facts of your case, so I can't answer that question. But the reason that you're here is it's my understanding that you've agreed to be extradited back to Alabama. Is that correct?
Yes, ma'am.
Right.
The non-vehicle and then offer on. And
Then at this time, oh, there's two.
So how long do they have to condition?
I'll sign that. Okay.
I know, but see, they said I got it.
I'll give it back to you. I'm sorry.
They said
I'm sorry. Next, I have Wade. Jamiron Wade. All right. Good luck, sir. So he also waived, and he's going to be extradited to Louisiana. Sir, please tell me your name.
Jamiron Wade.
All right, sir. You're here today because you have a charge actually in Louisiana. It says the charge is first-degree rape. The victim is under 13 years old. It's my understanding that you've agreed to be extradited back to Louisiana. Is that correct?
Yes, ma'am.
All right, then at this time, I will sign this order. All right, good luck, sir.
Thank you.
Next, I have Clairvaux. Good morning, sir. Please tell me your name.
Robinson Clairvaux.
I'm sorry?
Robinson Clairvaux.
All right, sir, you're here today because you have a charge in Georgia, and it's my understanding that you have agreed to be extradited to Georgia. Is that correct?
That is correct.
All right, then at this time, I will sign that warrant. Good luck, sir.
Thank you.
I mean, sign the order, not the warrant. Just two. All right. Next, I have Nigeria Jones. I just saw him yesterday.
Oh, no, on the open container.
Yeah. Good morning. Please tell me your name.
Nigeria Jones.
Mr. Jones, I believe we saw each other yesterday.
No, it was Sunday.
2 days, okay.
Monday
2 days
one.
ago. All right, so you're here today because you actually have a charge out of Walterboro, South Carolina. And it's my understanding you've agreed to be extradited there. Is that correct? You have to answer out loud.
Yes, ma'am.
All right. Then at this time, I'll sign that order. Good luck, sir. Sorry. I just have to make sure. All right, this one is the one you were just telling me about, California.
Correct.
All right, so I don't need him in here. Because this one doesn't say that, so I don't need him in here.
But now that second order,
I don't need Paul Defendini Lenderman. I don't need to see him. The second one is the order.
The second one is the order to remand. One is the dismissal. Of matter in effect services government warrant. This one, I believe, is the order to remand, and at the bottom, it provides a deadline for the court to set should the defendant have counsel and decide to challenge the governor's warrant by filing a writ for habeas corpus.
How many days does he have to do that?
It's the discretion of the court. We usually do anywhere between 5 and 10. So business days, so it would be next Friday or the Friday after, your discretion.
What's that?
Is it the 12th and the 18th?
All right, I'm going to do the 18th of February.
Okay.
Is that it?
That was it.
Thank you.
Thank you very much.
All right. Well, I didn't do that between each one.
So they have Gillard now. So if you want to address that one, then do the Spanish.
Good morning. Please tell me your name.
Donald Gillard.
All right, you're here, sir, because you have a warrant from another county.
Lake County.
All right, and at this time it says there's no bond.
Is there any way I can get a bond, ma'am?
Not today.
I've been here since the 2nd.
Of
January 2nd. And it's like I have health issues. I just got out of the hospital having surgery. I got cancer. I'm trying to get out so I can take care of, because if I don't get my other medication from my primary care doctor, I could die. And it's like, you know, and they keep sending me out to the hospital. Just got back from the hospital yesterday.
All right. Was the PD previously appointed in this case?
Can I see that last sheet? I can tell you.
This one?
Yes. Which case is this?
I don't see PD appointed.
No, it's not worth it.
All right, so this is Donald Gillard. I'm going to appoint the public defender to represent you so that they can take a look at your case and see what we can do for
It's
you.
a misdemeanor. It's over a year old. It's a misdemeanor driving on the spill with no valid driving license and paraphernalia. Violation of probation.
Yeah, it says narcotic equipment possession and no driver's license, no bond.
I'm going to plea on it today, Your Honor.
So because this is a Lake County case, I can't accept a plea without leave of court from Lake County.
Is there any way I can get a bond?
Not today, but I've appointed the public defender to represent you. So she's going to look into your case today, and we're going to see if we can make contact with Lake County and see if we can coordinate.
It's been over a month and Lake County ain't responded back.
But she can coordinate with Lake County, and we can figure out if I can accept a plea on behalf of Lake County. So that's what we'll do.
Okay.
If they're not going to come and get you, we'll see if we can coordinate a plea.
Yes, ma'am.
All right? Good luck, sir. Now Spanish?
Yes. And then we have Creole at 10.
Good morning, Your Honor. This is Alan Figueroa, State Certified Court Interpreter.
Have you been sworn this morning?
Yes, Your Honor.
All right. We have someone here with the headset. If you could please connect and see if he can hear you.
Will do, Your Honor. Just 1 second.
Sí.
The defendant can hear me, Your Honor.
Please tell me your name.
Selvi Giovanni Escalante Valenzuela.
Selvi Giovanni Escalante Valenzuela.
Sir, you're hearing case number 21CT972AO, charged with no valid driver's license. I've reviewed the probable cause affidavit. I do find probable cause exists in this case. I'll appoint the public defender to represent you. Your bond is $500, sir. You're not allowed to drive without a valid driver's license. Do you understand?
Your Honor, if the defendant would like to, if
Yes.
the defendant would like to enter a plea today, the offer would be an adjudication of guilt, credit for time served.
Sí.
Yes.
Are you interested in doing that today, sir?
Sí.
Yes.
You understand that if you enter a plea of guilty or no contest this morning, you'll be waiving or giving up certain constitutional rights. And if you're not a United States citizen, this plea could subject you to deportation.
Entendido.
Understood.
Yeah.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Sí.
Thank you.
Yes.
Sir, as I just briefly explained, you put your hand down. By entering this plea today, you're going to be waiving or giving up certain constitutional rights, including your right to remain silent, your right to testify on your own behalf, your right to present any witnesses that you have, any defenses that you may have, your right to a jury trial where one is required. You understand you're giving up all those rights today?
Sí.
Yes.
You understand if you're on probation, this plea could violate that probation?
Sí.
Yes.
And you previously told the court that you understand if you're not a United States citizen, this plea could subject you to deportation.
Correcto.
Correct.
All right, at this time, sir, how do you wish to plead to the charge of no valid driver's license?
Perdón. No me opongo.
No contest.
I'll accept your plea of no contest. What did the state say was the offer?
Adjudication of guilt, credit for time served.
I'll adjudicate you guilty, give you credit for the time that you've been in jail, which is how many days?
2 days, Your Honor.
2 days. I'll order you to pay court costs, and I'll give you a year to pay those court costs. Do you understand?
Entendido.
Understood.
All right, good luck, sir. I don't think I had these. Did I get these this morning? I haven't seen these.
Oh, this is one of my other felonies that. No, both of them. You didn't get the original.
Well, I can't do this right now. Sir, tell me your name.
Luis Cruz.
Luis Cruz.
You have several cases, sir. All right, it looks like you have an out-of-county case, a warrant for your arrest in 21 CT 103AX, charged with failing to appear on a charge of driving while license suspended. The bond is $1,000. The next case you have is 21 CT 103AX. Well, that might be the same case, actually. Yeah, that's the same case. So 20 CT 8720AX, you have an out-of-county warrant from Marion County for driving while license suspended. That one's a different case number. Your bond in that case is also $1,000. And then you also have case number 21 CF 1407AO. You're charged with possession of fentanyl, possession of MDMA, possession of drug paraphernalia, and providing a false identification to law enforcement. I'll have to review this probable cause affidavit because I've not seen it this morning. So who did that? I can't. They have to give them to me ahead of time. I can't do this.
Yeah,
So-
no, I understand.
Who did that?
Did you need to know the child the written time in the morning? I think that's what happened. It didn't get pulled out.
I'll email it.
Oh, they gotta tell us that, because I can't, I have to review them before I come to court. But I don't know who does that. Does the clerk's office do it or somebody else?
It's provided to us by correction.
Corrections, okay. All right, sir, having reviewed the probable cause affidavit, I do find probable cause exists in this case. I'll appoint the public defender to represent you. Your bond amounts are $1,000 on count 1, $150 on count 2, $100 on count 3, and $100 on count 4. If you post that, you're not allowed to possess or consume any illegal substances, and you're not allowed to have contact with any known drug dealers. Good luck, sir. No. They need to move that one. I can't do that. Okay. I need to review that. What's his name? What's your name, sir?
Jorge Luis Marrero Perez.
Oh.
Jorge Luis Marrero Perez.
You're hearing case number 20 CT 2856. Looks like you have a warrant out of Osceola County for failing to appear on a no valid driver's license. The bond amount is $2,999. Good luck, sir. So they just need to reset that one this afternoon?
To this afternoon?
Yeah.
Okay. Got it on correction.
Is that all we have for Spanish speaking?
Yes, Your Honor.
Okay, thanks. Thank you, Mr. Interpreter. I appreciate your time this morning. Yeah, because I don't have time to read them, and that one has a lot of stuff, so I can't do that really quickly. Thank you. No problem. And I'll have Teresa talk to him too. So
I'm so sorry, Madam Clerk, did we see a De Thomas? What happened to De Thomas?
That's the case that she wasn't ready to address.
Did
She's
not-
not ready to address it.
We're going to do it this afternoon because there's
Okay.
too many things. I can't review it on the bench, and I didn't have that PC before court.
So we're just
Hold
going to recall it second session?
Oh, yeah,
Okay.
because I can't review the probable cause affidavit, and, I mean, I can, but it'll take a few minutes. All right. What's your name, sir?
Kelby Patino.
You're hearing case number 21 CF 13290, charged with aggravated child abuse. There was a warrant issued for your arrest. I'm going to appoint the public defender to represent you. Counsel, based on this charge, is this a punishable by life offense?
I'm sorry, what's the defendant's last name, Your Honor?
Kelby. Oh, no, I'm sorry, Patino. From yesterday.
Yes, I don't believe the aggravated child abuse is a punishable by life felony, no, Your Honor.
You don't believe it is?
I don't believe so. But if you give me one more second, I can look it up again.
Okay.
I thought my notes, I don't have it as.
Based on the facts that are in the affidavit for the warrant,
I have it as a second degree, Your Honor, felony.
is it your understanding that he would be entitled to bond?
I'm sorry, Your Honor, it's a first degree. Yes, I believe he's entitled to bond. It's not a life felony, it's up to 30 years. The state would recommend a high bond, though, given the facts of the case, Your Honor. No contact with the victim, no contact with any children under the age of 18.
So your bond is going to be $100,000. You're not allowed to have contact with the victim or any of the victim's family members, and you're not allowed to have contact with any children under the age of 18. Do you understand? You have to answer out loud.
Yes, ma'am.
You're also not allowed to have contact with any witnesses in the case. Are there any other special conditions? You're not allowed to possess a weapon, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Thank you.
Good morning. Please tell me your name.
Sean Gaines.
You're here in case number 21 CF 1402AO, charged with aggravated battery domestic violence. I'm going to appoint the public defender to represent you.
Your Honor, we, oh, he said he already has a lawyer.
You have an attorney?
Yes.
What's your attorney's name?
Leslie Sweets.
All right. Then I will not appoint the public defender. The information I have indicates that he's a violent felony offender of special concern. At this time,
Your Honor, for today's purposes, I am reviewing the arrest affidavit. We see a domestic violence, not an aggravated battery. If this is Sean Ganger.
Yes.
And we would just ask for the charge to be domestic violence as opposed to an aggravated battery. He threw a chair. And in order to have an aggravated battery, it needs to be an object that can cause great bodily harm or likely to cause great bodily harm.
or if the victim is pregnant.
Correct.
The victim is pregnant.
Oh, okay, Your Honor. I didn't see that.
The victim is pregnant. So in this case, it will be an aggravated battery. Based on the facts of the case and the fact that he's a violent felony offender of special concern at this time, I'm not setting a bond. And I'm also going to revoke your bond in case number 19 CT 7533AO. Sir, even while you're in custody, you're not allowed to have any contact with the victim. That includes third-party communication and electronic. Do you understand that?
Yes.
All right, good luck. It's okay. Yesterday I was on a roll. I hit it every time. Today, we're already not on a roll.
She didn't say.
Please tell me your name.
Israel Jackson.
All right, good morning. You're here in case number 21 CF 1409AO. You're charged with battery by strangulation, domestic violence, tampering with a witness, grand theft, third degree of a firearm, possession of ammunition, 5 counts of possession of ammunition, possession of MDMA, possession of drug paraphernalia, possession of cannabis under 20 grams, possession of ammunition by a convicted felon, and possession of firearm by a convicted felon. I will appoint the public defender to represent you. I've reviewed the probable cause affidavit. I do find probable cause exists in this case.
Your Honor, we would argue that there's no probable cause for the possession of ammunition by a convicted felon.
I saw the gun, Your Honor, but I didn't see, I see a supplemental report for the ammunition. If you look towards the bottom, maybe the fourth line from the bottom. So I didn't see the actual ammo. I see the gun. They discussed the gun, but I didn't see the ammunition.
Hold on. I thought the bullets were in the gun, but let me reread.
Maybe I missed that, Your Honor. I just didn't see it.
If we don't have the bullets in the gun, what says the state as to those charges?
They have no objection to ROR, since we have so many other counts, Your Honor, no objection to the ROR as to counts 4 through 8, and then I believe it's count 12.
12, right.
Yes,
There's
Your Honor.
another one over there.
And then setting bonds, standard bonds on all the other cases, the other counts, excuse me.
All right, sir. Your bond on count 1 will be $25,000 on count 2. Does the state object to subsidiary bonds?
No, Your Honor.
$150, count 3, $150. Count 4 through 8, release on own recognizance. Count 9, $150. Count 10, $100. Count 11, $100. Count 12, released on own recognizance. And count 13, $150. You are not allowed to possess or consume any alcohol or illegal drugs. You are not allowed to possess a weapon of any kind, including a firearm or ammunition. Do you understand?
Yes, ma'am.
You're not allowed to have any contact with the victim. That includes third-party communication as well as electronic. Do you understand that?
Yes, ma'am.
I'm going to order that you maintain a separate residence. Do you live here?
I did, but I could go live with my grandma.
All right, then I'll allow a one-time return with law enforcement to gather your belongings, but you may not have contact with the victim to do
Yes,
that.
ma'am.
Do you understand?
Yes, ma'am.
All right, are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Yes, ma'am.
Oops, that's this too. Good morning, please tell me your name.
Hello, my name is Katie and Miko.
You're here in 21 CF 114180, charged with felony battery, great bodily harm, and battery by strangulation, domestic violence. There was a warrant issued for your arrest. Your bond on count 1 is $10,000. Your bond on count 2 is $150. You're not allowed to have any contact with the victim. That includes third-party and electronic communication. Do you understand?
Yes, ma'am.
You're not allowed to return to the scene. Do you live together?
No, but the scene is my warehouse. She doesn't live there. It's the warehouse for my business. She doesn't come. She doesn't like come to my business like without.
All right, just a moment, sir. Madam Prosecutor.
I'm sorry, Your Honor.
I'm sorry to interrupt. I just need to know what says the state about the scene. I would ordinarily say he's not allowed to return to the scene.
Just no contact in separate residences. So if she is at his warehouse, then obviously he can't be there.
All right. So I'm not going to order that you not return to the scene, but I will order that you maintain a separate residence and you're not allowed to have any contact with her. So as the prosecutor said, if she shows up at your warehouse, you have to leave. Do you understand?
Yes.
You're not allowed to possess or consume any alcohol. You're not allowed to possess a weapon of any kind, a firearm or ammunition. Do you understand?
Yes.
Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Did I
Thank
appoint the
you.
public defender?
I didn't.
I will.
I didn't hear you, Your Honor. Thank you.
I'm appointing the public defender. Sorry, ma'am.
She did 150.
Good morning. Please tell me your name.
Okay.
You're here in case number 21 CF 14060, charged with aggravated assault with a weapon, domestic violence. I'll appoint the public defender to represent you. I reviewed the probable cause affidavit. I do find probable cause exists in this case. Your bond will be $2,000. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. Do you need to return to gather your belongings? Ma'am.
No, I don't need to return there.
All right.
I do need to return there to gather my belongings.
I'll allow a one-time return with law enforcement, but you're not allowed to have any contact with the victim. Do you understand?
Yeah, I understand.
All right. I'm going to order that you are not allowed to possess a weapon of any kind, firearm or ammunition. And that's all. Good luck, ma'am.
I'm sorry, Your Honor, what was the bond amount?
$2,000. Thank you. Oh my goodness. Yesterday was doing 3. Good morning. Please tell me your name.
Daniela Baez.
You're here in case number 21 MM808AO, charged with battery, domestic violence.
Correct.
I'll appoint the public defender to represent you. I do find probable cause exists in this case. Counsel, I noticed that she does qualify for pretrial release. Does the state object to that?
Oh, I'm sorry. No, Your Honor.
All right, I'm going to place you on pretrial release. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. Do you need a one-time return with law enforcement to gather belongings?
I'm sorry, can you repeat that one more time?
Do you need to return one time with law enforcement to gather your belongings?
No, I have my boyfriend. He already took all my stuff out.
Okay.
Yep.
So maintain separate residence, no contact at all.
Yes, ma'am.
And are there any other conditions? No weapons, firearms, or ammunition?
No.
Anything else from the state?
No, Your Honor.
Good luck, ma'am.
Okay.
Good morning. Please tell me your name.
Munir Davis.
You're here in case number 21 MM816AO, charged with battery, domestic violence. I've reviewed the probable cause affidavit. I do find probable cause exists in this case. I'll appoint the public defender to represent you. Ma'am, do you wish to be heard? You don't want to speak?
I just don't.
I can't hear you. You have to get really close to the microphone.
I said I just don't want no contact. That's all.
Okay. I'm just going to have you raise your right hand to be sworn and put that on the record.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Can you state your name for the record?
I'm Mary Davis.
All right. And ma'am, you just told the court you don't want to have any contact with Munir Davis? You have to answer out loud.
No.
All right.
And I just have one more question, Your Honor. Does he have stuff at your residence?
Yes.
Okay, thank you. No further questions, Your Honor.
All right.
Then no objection to
He
a one-time
qualifies for pretrial release.
I can ask her if she has an objection. Ma'am,
Yes, please do.
Do you have a problem if the defendant is released without having to post a bond?
No.
No, ma'am. Okay. She said no, Your Honor.
She said no?
Yes.
All right. At this time, I'm going to place you on pretrial release. You're not allowed to have any contact with the victim or any witnesses in this case. I'm ordering that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot contact her to return. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon, firearm, or ammunition. Was alcohol involved in this?
No.
No. All right. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you, ma'am, for coming. Good luck.
GOT that is pulled out of second session. Do you want to call it, or you want me to leave it in second session?
Why did they do that? I haven't seen it.
Yeah, it was on the move up list as well. So we can leave it for a second.
Yeah, let's leave it because it needs to be reviewed. Thank you. Good morning. Please tell me your name.
So we're not calling.
Sir.
Tyrell Garner.
Mr. Garner, you're hearing case number 21MM807AO, charged with battery, dating, violence. I reviewed the probable cause affidavit. I do find probable cause exists in this case. I'll appoint the public defender to represent you. Counsel, it says he qualifies for pretrial release. Any objection by the state?
No, Your Honor.
All right, sir, I'm going to place you on pretrial release. You're not allowed to have any contact with the victim. That includes third-party and electronic communication. Do you understand?
Yes, ma'am.
Do you live together?
Yes.
Not anymore. I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you may still not contact the victim to do that. Do you understand? You have to answer out loud. All right. You're not allowed to possess a weapon, firearm, or ammunition. I don't see alcohol in this either.
It was involved, but
It was or was not?
it was.
All right, then I'm going to order that you're not allowed to possess or consume any alcohol, and you'll be subject to random screens. Good luck, sir.
Thank you. Do I have a quick, meaning what?
I'm sorry?
Can I ask a question or?
Yes.
You say I'm gonna be what, because of the alcohol?
You're not allowed to possess or consume it. So you can't hold a beer, you can't drink wine, nothing.
I mean,
And then you'll have random alcohol screens.
That wasn't when it happened, but she said I can't drink at all no more.
Right. You cannot drink at all. And you'll be subjected to random alcohol screens. So if you drink and then you get screened for alcohol and you test positive, your pretrial release will be revoked and you're going to come back to jail.
And then if we want to get this case dropped, what do you have to do?
That's between the attorneys. That has nothing to do with the court.
No, meaning between me and my girl, like.
You can't talk to her. I've ordered you not to have any contact with her.
If we want to like get it dropped so that we can come back together, we can't do that? Or
There's
something?
no we. Right now, you can't have any contact with her. So you talk to your lawyer, and your lawyer can advise you.
All right.
All right, good luck, sir. Please tell me your name.
Crystal Corin.
All right, ma'am, you're here on a habeas for failing to appear for a status hearing for the charge driving while license canceled, suspended, or revoked. The bond on that is $2,750.
Yes, Your Honor. The state has made an offer for Ms. Corin, adjudication of guilt, credit for time served. Looking at her driving record, I see a duelist from 2018 as this will be her second within 5.
That's 4 days.
What?
You have 4 days time.
Oh, thank you.
How many days?
She also has an out on bond case.
I did not look that up. Sorry. May I have a moment, Your Honor?
Yes, and the out on bond case is 2019 MM 9976AO. One of the charges is driving while license suspended.
996.
9976.
Oh, 996. Sorry.
I don't believe I appointed the public defender yet, but I will appoint the public defender in this case. Counselor, I'm inclined to revoke her bond on her out on bond case, just so you know.
She previously had the public defender's office on this case, Your Honor.
Okay.
Your Honor, we would ask that you take no action on the out on bond case. It's, from what I can see, it's a driving while license suspended, trespass, and possession of drug paraphernalia. These are all nonviolent crimes. If the court is inclined, we would accept the offer today and ask for no action on the out on bond case.
If she wants to accept the state's offer, I'll sentence her today, but I'm going to revoke her bond because she was out on bond on a driving while license suspended and got a new one. Ma'am?
Your Honor,
Just a second.
state's going to make an offer on the out on bond case as well.
Okay, hold on then.
Me to hold on? Or
No, them.
Oh, okay, sorry.
Go ahead, so she can hear it and then talk to her client. So.
Okay, yes, the offer to resolve 2019, excuse me, MM 9976 is on count 1, a withhold of adjudication. And this is the offer that was already in our system, a withhold of adjudication, credit for time served on counts 1 and 3, state on null pros count 2, court costs.
You're gonna null pros the driving while license suspended?
Yes.
Oh, well. And what are you doing with the trespass?
Withhold credit for time served on that one as well. So the paraphernalia and the trespass, a withhold credit for time served on the duelist, a null pros.
And what was your offer in the 20 CT 3051?
That was an adjudication credit for time served.
Okay,
She has 6 days on the outbound bond case.
thank you.
And a no return as well, Your Honor, on the trespass.
Your Honor, my client's going to accept the state's offer.
All right, ma'am, raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
All right, your attorney just told me that you'd like to enter a plea this morning. Is that true? You understand that by entering a plea of guilty or no contest today, you're going to be waiving or giving up certain constitutional rights.
Yes.
Like your right to remain silent, your right to testify on your own behalf, your right to call witnesses and present any defenses you have, your right to a trial by jury where one is required. You're giving up all those rights.
Yes.
You understand if you're on probation in any jurisdiction, this plea could violate that probation?
Yes.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes.
All right, one at a time then. As to case number 20 CT 3051, how do you wish to plead to the charge of driving while license suspended?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty. Order you to serve 4 days in jail, give you credit for the 4 days that you've served, and I'll order you to pay court costs. I'll give you a year to pay those. As to case number 19MM9976AO, how do you wish to plead to counts 1 and 3?
No contest.
Accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit time served for the 6 days that you've been in. I'll order that you pay court costs. I'll give you a year to pay. I'll also order that you're not allowed to return to wherever the car was. If the state has an address, and then if the state has an announcement as to count 2.
May I have 1 second for the address? Yes, state will announce a null pros as to count 2 in contemplation of the plea. And then for the address. State's gonna remove the no return. It was a truck that was stolen.
Right, it was a conveyance, so I thought,
yes.
this is odd.
Yes.
Okay, so there's not a no return. All right, good luck, ma'am.
Thank you.
I'm sorry, how much credit did she have in the 2019 case?
6.
Okay, thank you, Your Honor.
Yes. I'm ready.
You need arraignment, Your Honor?
Wait, don't we have one more? An out of county?
Oh, that's Hempfield.
Hemphill?
Chili Lash.
Oh, all right. Just kidding then. Yes, I'm ready.
Joseph Barley is medical.
All right. 2021 CT 9 AW. I will appoint the public defender to represent him. This is a Division 83 case.
Your Honor, we'll waive and enter a plea of not guilty.
All right, so his next court date is
Division 83 pretrial conference, March 24th at 9 o'clock, courtroom 6C.
Thank you, ma'am.
No problem.
Robert Mitchell, medical.
21 CT 724 AO is already represented by the Office of the Public Defender.
Your Honor, we'll waive and enter a plea of not guilty.
Division 81 pretrial conference, March 12th at 9 o'clock, courtroom 4E.
Alejandro Ramirez.
Funded.
I was gonna say, we just saw him.
That's what I thought. Okay.
Right.
Your
Johnny Ross. What's your name, sir?
Johnny Roll.
Sir, you're here in 20 CT 1130AE, charged with driving while license suspended. I can't tell if the PD was appointed, but I am appointing the Office of the Public Defender to represent you. It's a Division 80 case.
Oh. Your Honor, we're going to enter a plea of not guilty.
Division 80 pretrial conference, March 25th at 9 o'clock, courtroom 9C.
Good luck, sir. Good morning. Please tell me your name.
Michael Pierre Johnson.
You're here in 21 MM 261AO. You're charged with trespass in an occupied structure, and I show that you're represented by the Office of the Public Defender, sir.
Yes, Your Honor. Can I have just a second?
Yes.
Okay, Your Honor. My client wants to accept the state's offer of an adjudication of guilt, credit for time served, no return to the racetrack at 12136 South John Young Parkway, Orlando, Florida 32837.
Sir, please raise your right hand.
Raise your hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
All right, Mr. Johnson, you heard what your attorney just said.
Yes, ma'am.
Is that what you'd like to do here today?
Yes, ma'am.
You understand that by entering a plea of guilty or no contest today, you're going to be waiving or giving up certain constitutional rights,
Yes, ma'am.
like your right to remain silent, your right to testify on your own behalf, your right to call witnesses at a jury trial and present defenses. You're not going to have a jury trial today.
Yes, ma'am.
And that's what you want to do?
Yes, ma'am.
You understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
All right, sir, other than what your attorney just said, what we've talked about here in the courtroom, has anyone threatened you or promised you anything else to get you to enter this plea?
No, ma'am.
All right, then at this time, how do you wish to plead to the charge of trespass in occupied structure?
Guilty.
I'll accept your plea of guilty, sir. I'll adjudicate you guilty. I'll give you credit time served for the 25 days that you've been in jail. I'll order that you not return to the racetrack, and the address is what your attorney just said. Sir, I have to order that you pay court costs. Do you have a job?
No, ma'am.
All right, I'm going to reduce it to a lien. All right, good luck, sir. Thank you.
Thank you, ma'am.
33-day motions.
Yes, Your Honor.
LaShonda Morgan, 20 CF 14562AO.
That should be denied. The state filed an information today, 2-4.
Same name, 20 MM 8697AO.
Should be denied. The state filed an information this morning, 2-4.
Liazid Abad, 21 CF 67AO.
And that should be denied. The state filed an information this morning.
Excellent. Do we have Mr. Hempel? Mr. Hempel?
Hemphill.
Roosevelt?
Hemphill.
Hemphill, Hemphill.
Oh, man. Okay, I'm doing your arraignment offers for Monday.
Okay.
Working on those now.
You're going to be here this afternoon?
No.
Oh, it's someone else, right?
Yes. But I wrote all the offers, well, you saw, the offers are all written down and all that stuff's done, so. I have a training this afternoon.
Why do you want to leave?
You said what?
You're going to be leaving us soon? Somebody's going to replace you?
Huh?
Somebody's going to be replacing you soon?
Yes.
We don't want you to go. They have big shoes to fill. I don't know.
I'll still be here. I'll be around.
I forgot about this yesterday. What is this?
Would you be doing the specialty courts or you? No?
It was just sitting up
Just
here.
supervising?
So then I signed up and then I thought, wait a minute.
Yeah.
Oh.
So 3 times service been handed to you. I'm not sure how it was handed to you.
This was up here yesterday. Am I supposed to sign that? I did, and then I realized, oh, I should ask about that. Hold on, let's address this case and then we'll talk about that. Sir, please tell me your name.
Roosevelt Hemphill.
I'm sorry?
Roosevelt Hemphill.
All right, sir, you're here in case number 201775 CF. 20 CF 897, 2017 74 CF. You have several out-of-county warrants, sir. It looks like this one is from St. Johns County for burglary of an unoccupied structure, grand theft, and criminal mischief. Your bond is $5,000 on count 1, $5,000 on count 2, and $2,500 on count 3. Hold on, I'm trying to read what this says. You have an additional warrant, 201775 CF, burglary of an unoccupied structure. Bond is $5,000, grand theft. Bond is $5,000, criminal mischief. Bond is $2,500. So those are the correct bond amounts.
Your Honor, on the warrant for 21774 CF, he was seen with Judge Schreiber back in January. The first teletype we received from St. Johns County, it gave us 4 counts. On the court order, it shows 4 counts for that case with $5,000 each. However, yesterday we received a corrected teletype and they sent over the actual warrant for that case, and it's only supposed to be 3 counts, which was burglary of an unoccupied structure for count 1 with a $5,000 bond, count 2 grand theft with a $5,000 bond, and count 3 of criminal mischief of $2,500.
I see that, and it's a capias, sir. So those are the correct bond amounts?
Yes, we just needed a corrected amended order.
All right. So we'll correct that. There's only 3 counts on that warrant, not 4. And those
Yes,
are
Your
the
Honor.
correct bond amounts.
Yes, Your Honor.
All right. Good luck, sir.
This is how I type it out. I just put justice writing, this is Gibson, and then you'll sign it for emergency fiber. Or do you want me to change that? 'Cause
And I can always just put 4 out to the side.
Okay.
So I'm not, that's fine with me.
Okay.
All right. Any other matters before the court recesses this morning? Thank you,
Your
sir.
Honor.
All right. Court will be in recess.
Yeah. Ready to rock and roll. All right, can I get the state and the PD? Put the name on the record.
Annette Frere on behalf of the state of Florida. Letitia George on behalf of the Office of the Public Defender.
All right, George, and you are
Hey,
here
Judge,
for.
I'm Tom Fighter on behalf of Edgardo Alicea. I'm a private counsel, just have one case here today, but.
Alicea?
Alicea, Edgardo.
Okay, so he's second. He's gonna be second on my list here.
No worries. My first time being in front of you, Judge, so it's good to see you. And
Yeah, well, in person.
in person,
We
yeah,
had
that's for
some
sure.
virtual pre-trials
Yep,
last year.
yep. Oh yeah. So, well, very good.
Okay. All right. So the first case I have is Julio de Thomas.
He's going to be medical, Your Honor.
All right, and he's here for 2 cases. The first case is 21 CF 1397 AO and 2021 CF 1398 AO. I'm going to appoint the public defender to represent him. Ms. George, do you want to waive his appearance?
Yes, Your Honor, we'll wait.
All right, Mr. De Thomas, review the charging affidavits. The court did find probable cause in both cases. I'm going to stay his bonds. In 2021 CF 1397 at $1,000. Condition of his bonds, he's not returned to the scene, have no contact with any victims or witnesses. In 2021 CF 1398 AO, the court's going to stay his bonds as to that case as well. $5,000 is account 1, 500. Condition of his bonds, he's not returned to the scene, have no contact with any victims or witnesses. He was on probation in 2020 CF 1690 and 2020 CF 3297. And in those cases, the court's going to find an on-view violation, set his bonds at 0 in those cases.
Your Honor, they currently have those on his account already, on the on-views. You want to put?
No, that's fine. No, it was success state probation. Nobody gave me any cases.
Oh yeah, they added them on later, so they'll be seen tomorrow.
We do the on-view now, and then you can get a warrant whenever, and we can do the warrant when it comes in. With no point of bringing them here just to do on-view and then bringing them back and then another day to do a warrant.
Oh, okay.
Or is that not economical, or?
I mean, they already set it, scheduled it.
Who set it, or?
Downstairs, inmate records.
Yeah,
they already added the on-views on. I guess the probation officer came.
Okay.
And they're set to be seen tomorrow. No, just on-view.
Okay.
The on-views.
Yes, I'll see them when they get the warrant.
Okay, so we don't need to do any on-view paperwork, or we still want me to do on-view Saturday at 9?
I was going to see him today. I don't want to see him tomorrow. So what we're doing is bringing him in for on-view. So just do the on-view now, and then I want to see him tomorrow until they actually file the warrant.
Okay.
Does that seem more reasonable not to transport somebody here they're probably still going to be in medical tomorrow?
I mean, they don't have the court. They don't have the orders.
Oh, we type an order. If he requests for us to type one, we're going to type one.
Okay. So you want me to print them out?
No,
The affidavits?
Okay. It's an on-view VOP by court.
Yeah. So not until when they file the actual VOP warrant, some judge is going to sign it. They're going to bring it to me or to the circuit judge that he's a division for. And then I'll see him again, initial appearances for whatever bonds the judge sets if he changes it from 0 to something else.
Okay. No, but I was saying, because they already set it in the system for on-views. So you don't want him to come back tomorrow on
No,
those
ma'am.
they already served on him?
Correct.
Okay.
I want to appoint a public defender to represent him in all his cases, in the VOP cases and the new cases, so he'll have representation while we're waiting.
Okay. And I'll give you those 2 orders to sign.
Yes, ma'am. All right, I have, sir, can you tell me your name?
Ricardo Licea.
All right. Ms. Alcea, you're here in 2020 CF 14932 AO on a warrant for aggravated stalking after injunction and installation of a GPS tracker. Mr. Fighter, you want to put your name on the record?
Yes, good afternoon, Judge. Thomas Fighter on behalf of Mr. Alcea.
All right. Mr. Fighter, do you want to tell me anything for our set bonds or release conditions in his cases?
Yes, Judge. We're aware of this case. There is a pending injunction in which the alleged victim has a temporary restraining order. She is represented by an attorney in that case. He does have a DUI as well out of Kissimmee, out of Osceola County. That's been, I think it's just over a year old now. He was set to go to trial in that case early in January of this year, but it got continued out to, I think, late April because of COVID.
Okay.
So through no fault of his own, his case hasn't been resolved yet down there in Kissimmee.
I think I see Rachel Maddie's on the case.
Yes, sir. I do not represent him on that. But we would just ask that a bond in this case be set in keeping with the bond schedule. My client is a 47-year-old night shift NICU respiratory therapist. He was working at the same hospital as the alleged victim in this case. He has since been terminated from that job, so he's no longer there. I don't think that's a risk factor anymore. So we just ask that a bond be set in keeping with the bond schedule here. He doesn't live near the victim. He doesn't have any reason to have any more contact with her. So.
Okay. As the 2020 CF 14932AO, the court is going to set your bonds to count one in the amount of $3,500. $1,500 is to count two. Conditions of your bonds: to have no contact with the victim, to maintain a separate residence from the victim, no weapons, no firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You are to possess no drugs or alcohol during the course of your release on that case. You are to abide by any injunction that is in place. That's 2020 DR 12122AO as part of your release conditions. As to the case he's out on bond on, the allegation in the warrant from December 9th raises the court's concerns as to the ability for this defendant to be out on release. The court's going to revoke that bond in 2020 TR 229AO for an Osceola County case. I'm going to set new bonds at none in that case. You can reach out to Ms. Maddie, and she can set a bond hearing in front of, you know who your judge is?
I think it's Jan Savage, but I could
Right.
be mistaken.
Yep.
I'd only ask that because it's a year old, Your Honor, that it just be left alone or actually raise the bond amount because, you know,
the
it wasn't-
allegations in the warrant that he's involved in a hit and run accident while he's out on release on a DUI.
I mean, the DUI would have been resolved, but for the pandemic, it is.
But then you'd have been on a violation of probation.
Well, not if he gets a
Possibly,
not guilty.
I mean, if he would have been found guilty, he'd have been out on a violation of probation and would have been in the same position.
It's a 000 blow, and it's a 9:30 in the morning accident. I hear you, but I would just ask the court to.
I know the facts of his case.
Very good. I will communicate with Miss Maddie. As far as this case goes, though, the two bonds have been set, and I understand.
Yeah, you can bond out. I mean, once he gets to when he's Osceola, they can get in front of Judge John Savage and handle his bonds.
Very good.
All right.
Thank you, Judge.
All right. Have a great day, Mr. Fighter. Have a great day, sir.
Yes, sir. I'm gonna come back.
All right. I got Mr. Brown. All right. Slide over. Tell me your name, sir.
Cornelius Brown.
All right. Mr. Brown, you are here in 2021. MM 814AO on a charge of battery.
Battery?
Yes, sir.
I never hit anybody.
I'm telling you what they're charging.
They said it was simple assault.
Hold on, Mr. Brown. You have the right to remain silent, so listen to me. I'm going to appoint the public defender to represent you in this case. I reviewed the charging affidavit. I'm not saying you're guilty of this charge, but it seems that there's probable cause for your arrest as to this matter. I'm going to stay your bonds in the amount of $500. I'm going to make it a condition of your bond that you have no contact with the victim in this case, that you do not return to the scene of this location, that you not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You are to possess no drugs or alcohol without a valid prescription. I will make it alternatively that you can be released out on mental health pretrial release if you qualify with those same conditions. All right?
A bond or mental health pretrial?
Yes, sir. All right. Have a great day, sir. Tell me your name, sir.
William Sherry.
All right. Mr. Sherry, you are here in 2021 MM 815AO on charge of trespass after warning. I reviewed the charging affidavit in this case. I do find probable cause for your arrest. States that offer to resolve Mr. Sherry's case.
Yes, Your Honor. Adjudication of guilt, credit time served, and no return.
All right.
Your Honor, can I have just a moment to speak with the client?
Is he on random testing for this PTR?
I'm sorry?
Is he on random testing for the PTR? I don't know what his conditions were on PTR. For the felony case.
Your Honor, he's going to accept the state's offer.
All right, Mr. Sherry, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Put your hand down, sir.
No, he wasn't, Your Honor. He wasn't, Your Honor.
All right, sir. Can you tell me your name one more time?
Wilgan Sherry.
Mr. Sherry, you're here in 2021 MM 815AO on the charge of trespass after warning. That's a first-degree misdemeanor. It's punishable by 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes.
Did you want to enter a plea of guilty or no contest to that charge?
No contest.
Do you understand by entering a plea of no contest, you're given the right to have a trial?
Yes.
You're saying given the right to have an attorney appointed to represent you at a trial?
Yes.
At a trial, the attorney can challenge the state's evidence, it can question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes.
If there was a witness you wanted to call that did not want to come to court, do you understand that the court can use a subpoena power to make that witness appear? Do you understand?
Yes.
Do you understand you're given your right to remain silent?
Yes.
You understand you're given the right to appeal any errors in this case, except the court's jurisdiction over you and the sentence I'm going to impose. Do you understand that?
Yes.
Are you under the influence of any drugs, alcohol at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or forced you to enter this plea?
No.
You understand by entering this plea that if you're not a United States citizen, it could subject you to deportation.
Yes.
I reviewed the charging affidavit in this case. I do find a factual basis for the entering of your plea. I'll accept your plea of no contest. I'll find that your plea is freely and voluntarily entered. I will adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. I'll impose court costs and costs of prosecution in the amount of $273. I'll make those costs payable directly to the clerk within 1 year of today's date. Do you understand?
Yes, sir.
All right, sir. You are out on pretrial release in 2021 CF 21191. The court's not going to revoke your pretrial release, but I am going to modify it. I want to make it a condition of your pretrial release that you are you possess no drugs or alcohol at this time, and that you are subject to random drug testing at your expense. All right. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that, sir?
I'm sorry?
You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand?
Yes, sir.
All right. Have a great day, sir.
Thank you.
Darius Johnson, his behavior, Your Honor.
All right. Give me 1 second here. All right. All right, this is Mr. Johnson. Mr. Johnson has 2 cases in front of us. He has a 2018 case out of Brevard County and a 2021 MM 817AO resisting officer without violence. I want to appoint a public defender to represent him in this case. George, would you like to enter a plea? Sorry, not a plea. Sorry. You want to waive his appearance?
Yes, Your Honor, we'll waive.
All right, the court is going to stay his bonds as his Brevard case at the amount of $10,000. Making condition while he's here in jail that he had no contact with the victims in those cases and that he had no contact with any child under the age of 18 years old during the pendency of his release. He maintained a separate residence from the victim. He's possessing no weapons or firearms. Any weapons or firearms he has need to be turned over to law enforcement within 24 hours of his release. As to the 2021 MM 817AO, the court is going to stay his bonds in the amount of $500 on that case.
Ida Latoya Bell, refused.
All right, we're here on Miss Ida LaCoya Bell, 2021 MM 812AO. She was here on charge of trespass. The court found probable cause for her arrest as that matter. I'm going to appoint a public defender to represent her. Ms. George, do you want to waive her appearance?
Yes, Your Honor, we would just ask that you take no action on her out on bond cases.
I have a question. We just saw her not too long ago, correct?
I believe we did, Your Honor. There's mental health.
Yeah, I was wondering if she was on mental health pretrial release.
No, Your Honor.
No, she.
All right.
She
I'll
just-
say her bonds as set or mental health pretrial release if she qualifies.
And no action on all the
No, no action on the other bond cases. She seems to be incompetent in those other cases. Sir, can you tell me your name?
Frank Rivera Torres.
All right, Mr. Rivera Torres, you are here in 2021 MM818AO on charges of petty theft and possession of drug paraphernalia. Say you have an offer for Mr. Rivera Torres.
We do not, Your Honor.
I want to set your bonds as to the petty theft in the amount of $500. And we'll stay your bonds as to drug paraphernalia in the amount of $500. Conditions of your bonds that you do not possess or consume any drugs or alcohol without valid prescription. And you do not return to the scene of this location. And do not possess any, do not make contact with any victims or witnesses from this case. All right, have a great day, sir. All right, tell me your name, sir.
Corey Levon Harris.
All right. Mr. Harris, you're here in 2021 MO13AO on a failure to appear warrant. The judge signed the warrant, set your bond amount of $500. State, do you have an offer from the city to resolve this case today?
Your Honor, can you repeat the name one more time?
This is Corey Harris, 2021 MO13AO. I think the underlying charge was a city-county ordinance in violation for disorderly conduct.
Your Honor, we do have an offer. It's a withhold of adjudication, credit time served, 223 CC, 10 off. I'm sorry, the handwriting's not very good.
Well, it's $223 in court costs and it's $550 in prosecution. So, Mr. Harris, the state or the city is offering you a withhold adjudication of guilt, credit for time served. There's court costs and cost of prosecution amount of $273. Is that something you want to take today?
Yes, Your Honor.
All right, you raise your right hand and be sworn in. Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Your Honor.
And you put your hand down, sir. Tell me your name one more time.
Corey Levon Harris.
Mr. Harris, you are here in 2021 MO13AO on a charge of disorderly conduct. That is a second-degree misdemeanor. It's punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes, Your Honor.
You want to enter a plea to this charge. Would you want to enter a plea of guilty or no contest?
No contest, Your Honor.
Do you understand by entering a plea of no contest, you're giving up certain rights. One of those rights is you're giving up the right to have a trial.
Yes, Your Honor.
You understand you're giving up the right to have the court appoint an attorney to represent you at a trial.
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Have you now or in the past been diagnosed with a mental health illness?
No, Your Honor.
Has anybody forced, threatened, or coerced you to enter this plea?
No, Your Honor.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation. You understand if you enter this plea and you're not a United States citizen, it could subject you to from being deported from this country if you're not a citizen.
Yes, I'm a citizen.
All right, but do you understand that that's a possibility if you weren't a citizen?
Yes, Your Honor.
I have to tell everybody, so it's not particularly. All right, I did review the case before I came to court today, so I do find a factual basis for the entering your plea. I accept your plea of no contest to this charge. I will give you credit for
4 days.
4 days that you spent in the Orange County Jail with 4 days credit time served. I'll withhold adjudication of guilt. I will impose court costs and cost of prosecution. That's adjudication? Sorry.
It's just 223 because it's the MO.
It's 273?
223 because it's the MO case.
Okay, so 223 in court costs, and is it not $50 in court prosecution?
No, not on the city and county.
Then 223, I will make that payable directly to the clerk within 1 year of today's date. You have 30 days from today's date to appeal your judgment and sentence in writing. You understand?
Yes, Your Honor.
All right, have a great day, sir.
You too.
Can you tell me your name, ma'am?
Jennifer Agosto.
Ms. Augusto, you are here in 2020 MM 89 AO on violations of conditional release. The judge signing your warrant in this case set your bond at $500 as count one and $100 as count two. You can post those bonds if you can. I'll appoint the public defender to represent you in this case. Have a great day, ma'am.
Okay.
Sir, tell me your name.
John Darrell Herring.
Mr. Herring, you are here in 2021 MO 163 AO in charge of open container. I reviewed the charging affidavit in this case. I do find a factual basis for the entry of your plea. Says an offer from the city to resolve this case.
Yes, Your Honor, withhold of adjudication and credit time, sir.
Mr. Herring, do you want to accept the city's offer of a withhold adjudication and guilt credit time, sir?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
Yes, sir.
You put your hand down. Tell me your name one more time.
John Darrell Herring.
All right, Mr. Herring, you're here in 2021 MO 163 AO on charge of open container. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. You understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to that charge?
No contest.
Do you understand by entering a plea of no contest, you're giving up certain constitutional rights? One of those rights is that you're giving up the right to have a trial. Do you understand that?
Yes, sir.
You understand you're giving up the right to have the court appoint an attorney to represent you at a trial?
Yes, sir.
Are you under the influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I reviewed the charging affidavit in this case. I will accept your plea of no contest. Find it as a factual basis and the plea is freely and voluntarily entered. I will withhold adjudication of guilt. I'll give you credit for the 2 days that you spent in the Orange County Jail, and I will impose the court cost in $223. And I'll make those costs payable directly to the clerk within 1 year of today's date. You understand?
Yes, sir.
All right, you have 30 days from today's date to appeal your judgment and sentence in writing. You understand?
Yes, sir.
Have a great day, sir.
Yes, ma'am. On his Terry, you gave him earlier, he modified his condition.
Yes.
No drugs, alcohol,
Yep.
and to be randomly tested.
Correct.
Do you want him randomly tested through pretrial
Yes.
release?
I didn't revoke his pretrial release. I just modified his pretrial.
Okay, thank you.
He's like, hope I clicked the correct button on the other order last time.
No, I'm gonna type a separate order for this
Okay.
case. Okay.
Can you tell me your name, sir?
Wallace Lesmore.
All right. Mr. Lesmore, you are here in 2021 MO 164 AO on charge of open container. I reviewed the charging affidavit in this case. I do find a factual basis for the entering your plea. State, do you have an offer from the city to extend to Mr. Lesmore?
Yes, Your Honor, withhold of adjudication and credit time served and court costs.
All right. Mr. Lesmore, do you want to accept the state's offer of a withhold of adjudication and guilt credit for time served?
Sir.
It's up to you. You don't have to. Say again?
Yes, sir.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, none but the truth, so help you God?
I do.
And put your hand down. Tell me your name one more time.
Wallace Lesmore.
All right, Mr. Lesmore, you're here in 2021 MO 164 AO on charge of open container. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Yes, no?
Yes, sir.
All right. Do you want to enter a plea of guilty or no contest to those charges?
No contest.
You understand by entering a plea of no contest, you give up certain constitutional rights. One of those rights is that you're given the right to have a trial. Do you understand?
Yes, sir.
You understand you give the right to have an attorney appointed to represent you at that trial.
Yes, sir.
All right. Are you under the influence of any drugs or alcohol at this time?
Yes, sir.
You're under the influence of drugs or alcohol?
Alcohol.
I can't hear you.
Alcohol.
All right. Well, do you not understand what's going on? You think the alcohol is affecting you or you don't understand what you're doing here today?
Yes, sir.
All right. Well, I can do a couple of things. I can reset you for tomorrow morning, and we can resolve your case then once you feel like you're detoxed.
Resolve my case today.
Well, you're telling me that you are having trouble understanding why you're here and the sentence I'm going to impose.
No, sir.
I think he didn't hear you, Your Honor.
Okay. Well, I'll ask the question again. Are you under influence of any drugs or alcohol at this time?
No, sir.
Have you now or in the past been diagnosed with a mental health illness? Have you now or in the past been diagnosed with a mental health illness?
Yes, sir.
What was that mental health illness?
Depression.
All right. Do you take any medications for your depression?
Yes, I do.
All right. Do those medications help you understand the world around you?
Yes, sir.
Are you suffering from any of the symptoms of your depression right now?
No, sir.
Do you understand that if, by airing this plea, if you're not a United States citizen, it could subject you to deportation?
Yes, sir.
All right. I reviewed the charging affidavit in this case. I do find a factual basis for the entering your plea. I accept your plea of no contest, find it is freely and voluntarily entered. I'll withhold adjudication of guilt. I'll impose the court costs, in this case of $223. And I'll make the costs payable to the clerk within 1 year of today's date. I will, so you have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes, sir.
All right, have a great day, sir.
Yes, 2 days, right?
Yes, 2 days. Oh, yes, 2 days credit. All right, tell me your name, sir.
Sergio.
What's your full name, sir?
Sergio Vicente Moreno Jr.
Mr. Moreno, you are here in 2021 MO 165AO on a charge of camping. The court has reviewed the charging affidavit in this case. Have you found a probable cause for your arrest? States an offer from the city to resolve his case.
Yes, Your Honor, withhold of adjudication, credit time served, and court costs.
All right. Sir, the offer from the state of Florida is a withhold of adjudication of guilt, credit for time served. Do you want to take that offer today?
No contest, Your Honor.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and none but the truth, so help you God?
Yes.
All right, put your hand down. Sir, you're here in 2021 MO 165AO on a charge of camping. That's a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes.
You told me you want to plead no contest. Is that correct?
Yes.
Do you understand by pleading no contest, you're given the right to have a trial. Do you understand that? You're giving up certain constitutional rights if you want to enter a plea of no contest. One of them is the right to have a trial. Do you understand?
Yes.
You understand you're given the right to have an attorney appointed to represent you at a trial. Yes, ma'am.
Order revoking it's gonna look like. Okay, Your Honor.
All right, Mr. Moreno, do you want to give up your right to have an attorney appointed to represent you at a trial?
Do I want the right to an
No, do
attorney?
you want to give up? You have to give up the right. If you want to enter a plea of no contest right now, you have to give up the right to have an attorney appointed to represent you at a trial.
No.
You don't want to do that?
Nah, I want to end this right now.
Yeah, but you have to give up the right. So do you want to give up the right or not? You don't understand what
Okay,
what the word say
okay. Right.
Do you understand when I say the word right, what do you think I'm talking about?
When you say the word right?
Yeah.
That means that I'm playing that that I'm guilty, right?
Well, the Constitution guarantees you certain rights.
Okay.
So if you want to enter a plea, you have to give up those constitutional rights. So do you want to give up those constitutional rights? And one of them is to give up the right to have an attorney.
To take this
Yes.
to court? No, I don't want to do that.
I don't want to take. I'm not asking if you want to take it to court. I'm asking you if you want to give up your right to have an attorney.
Okay, yeah.
All right. Are you under the influence of any drugs or alcohol at this time?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or forced you to enter this plea?
No.
Somebody made you do this?
No.
You understand about entering this plea? If you're not a United States citizen, it could subject you to deportation. Do you understand?
Yes.
I reviewed the charging affidavit in this case. I do find a factual basis for the entering of your plea. I'll accept your plea of no contest. I'll find that your plea is freely and voluntarily entered. I will withhold adjudication of guilt. I will impose court costs in the amount of $223. Plus, I'll give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. You have 1 year from today's date to pay all the costs in this case in full. You have 30 days from today's date to appeal any errors from your judgment and sentence. Have a great day, sir.
All right. So I'm being, excuse me.
Thomas Banks, bonded.
Thanks. Can you tell me your name, sir?
Bruce Wonder Blunt Jr.
Mr. Blunt, you're here in 2021 CF 1405 AL on charge of fleeing and attempt to elude law enforcement. The court has reviewed the charging affidavit in this case. I find a factual basis for the entering your plea. I'll set your bond in this case in about $1,500. Additionally, your bonds that you're not to operate a motor vehicle without a valid driver's license. All right. Have a great day, sir. I'll appoint the public defender to represent you.
Generic Butts, refused.
All right, this is Miss Butts, 2021 CF 2021 CF 435 AO. She's on a charge of possession of controlled substance. I'm going to appoint a public defender to represent her in this case. Ms. George, you want to waive her appearance?
Yes, Your Honor, we'll waive.
All right, I'll review the charging affidavit. I did find probable cause for her arrest. I want to state her bonds, I believe, the amount of $1,000 on the arrest warrant. No, sorry. I want to lower her bonds to $1,000. I think it was $2,500 on the arrest warrant. Condition of her bond, she not possess any drugs or alcohol without valid prescription. All right. Say, what do you want me to do to our open case, with our open case?
Your Honor, you're referencing 2020 CT 846.
Yes, sir.
I believe the offer is adjudication credit time served for that case, and there's a status hearing coming up February 26th.
February when?
26th? 26.
Oh, interesting, because allegations in this arrest warrant is that she was operating a motor vehicle. Did she have a valid license at this time?
Your Honor, if we revoke her bond, she won't have the opportunity to try to get her license prior to that hearing.
Well, I guess the question is that a consideration that the statute tells you to take into consideration that she won't be able to cure the problem that she created. I'll do this. She has multiple driver license suspended convictions, no valid convictions. And the allegations of the arrest warrant, she's operating a motor vehicle. From what I can tell, when I looked up on David, that she still doesn't have a valid license. So the court was not even charged with that offense. But of course, in 2020 CT 846AA is going to revoke her bonds. That's that case. I'm actually going to give her a bond. We'll set bond amount of $5,000. Tell me your name, sir.
Crystal Saeed.
All right. Mr. Saeed?
Yes, sir.
You are here in 2021 CF 1403 AO on charge of possession of cannabis with intent to sell and deliver. The court reviewed the charging affidavit. I did find probable cause for your arrest as to this matter. I'm gonna stay your bonds in the amount of $1,000. I'm not going to take any action on your battery and trespass case. Seems they're going to breach all the versions, so they may come back later. All right, have a great day, sir. Appoint a public defender to represent you in all your cases. All right, tell me your name, sir.
Luke Charles.
All right, Luke Charles, sir, you are here in 2021 CF 1390AL on charge of possession of methamphetamine. Court reviewed the charging affidavit in this case. Found a factual basis for the I found probable cause for your arrest as to that matter. I'm going to set your bonds as to that matter in amount of $1,000. In 2020 position of your bonds in the 2021 case that you not possess any drugs or alcohol without a valid prescription. In 2020 CF 14271 AO, of course, going to revoke your bonds as to that matter. It's going to set your bond in count 1 in the amount of $2,500. Count 2, $500. Count 3, $500.
Your Honor, on that case, the state only filed on 2 charges.
Okay.
Which was possession of meth and trespass.
Okay, so I'll order him on the drug paraphernalia charge. I will still say his bonds at $2,500 as to the possession of meth charge, and then $500 as to the trespass charge. In addition of those bonds, that you have that do not possess any drugs or alcohol without a valid prescription, and that you do not return to the scene of the location where the trespass occurred. Have a great day, sir.
Thank you. Count 3 was the count that you all ordered.
I don't know. It's possession of drug paraphernalia. That's why I didn't. It's listed on the yellow sheet, but I don't know if it's the right order that he was arrested on. So, all right, sir. Tell me your name.
Primus Edwards.
All right, Mr. Edwards, you are here in 2021 CF 1396 AO. In that case, you've been charged with possession of cocaine, possession of arrested for possession of cocaine, possession of drug paraphernalia. Court reviewed the charging affidavit in that case. I'm going to stay your and found probable cause. I'm going to stay your bonds amount of $1,100 each on the 2 charges. Additionally, your bonds not possessing any drugs or alcohol without a valid prescription. You are here in 2021 CF 1279 AO. And in that case, the court reviewed. I think it was a warrant. No. Wait. Sorry. Yep. The judge signing your warrant already found probable cause for that case. The judge set your bond amount of $1,000 and $100. Additionally, your bonds do not possess any drugs or alcohol without a valid prescription. Appointed public defender to represent you. Have a great day, sir. Tell me your name, sir.
I'm sorry, Your Honor, what was that?
Tell me your name.
Carlos Etienne.
Carlos Etienne?
Yes, ma'am.
Right.
Yes, sir.
Mr. Etienne, you're here in 2020 CF 5627 AO on a failure to appear warrant. The judge signing your warrant set your bond at none. Your bond remain at none. We're going to appoint a public defender to represent you in this case so they can get you in front of that judge to address your bonds. Have a great day, sir. Okay, talk to Ms. George first if you got a question. Well, stay right there.
Thank you, Your Honor. Justice Ford bonded, Your Honor.
Mr. Fort bonded, and Mr. Grant.
Grant also bonded.
Yep. And I have Kevin Holmes.
Yes, sir.
All right. Sir, you're here in 2021 CF 1393AO on charge of grand theft motor vehicle. I reviewed the charging affidavit in this case. I did find probable cause for your arrest. It's going to stay your bond in the amount of $1,000 in that case. Condition your bonds: you do not operate a motor vehicle without a valid driver's license. You do not have contact with any victims or witnesses from this case. So you're out on bond in 2020 CT 158 AW. In that case, the court is going to revoke your bonds. I'm going to set a new bond in the amount of $5,000. I'm going to appoint a public defender to represent you in all your cases. Have a great day, sir.
You said the new bond is 5,000?
Yes, ma'am.
Okay.
So how much is that with 10%?
Lamborn, his behavior.
All right, Ms. Lamborn is here in two matters: 2020 CF 1391AO and 2021 MM 813. You want to appoint a public defender to represent her. Ms. George, do you want to waive her appearance?
Yes, Your Honor, we'll waive.
I reviewed the charging affidavit in these cases and find probable cause in both cases. I want to state the bonds as set. Condition of the trespass case: do not return to the scene of the location. Tell me your name, sir.
Zachary Latham.
Mr. Latham, you are here in 2020 CF 13290 and 2020 CF 13287. Both of the charges are the same: grand theft motor vehicle. The judge signing your arrest warrants found probable cause for your arrest. You're going to stay your bonds in those cases amount of $2,500 as to both cases. Condition of the bonds: to have no contact with any victims or witnesses. He's on state probation out of this county. I didn't have time to look him up.
Let me check.
See?
I can check.
Okay.
To see. Out of Duval County, Your Honor.
All right, I'm not going to take any action into his probation case. You know what the charge is?
Battery upon person 65 years of age or older.
All right. All right, Ms. Latham, you can bond out on these cases, but Duval County?
Duval.
Probably going to come looking for you really soon.
I was incarcerated the whole time.
Yes,
I got transferred here.
I'm just telling you.
I can bond out there, right?
You can bond out on these
Thank
charges,
you.
but
All right, appreciate it.
Duval, they come looking for you. You may not have any bond. That's in the Duval case. So
That's who brought me here.
yeah.
Yesterday.
Okay. All right,
Okay, thank you, sir.
All right. Can you tell me your name, ma'am?
Autumn Mercado.
Ms. Mercado, you are here in 2021 CF 1414AO on charge of introduction of contraband into a county detention facility and possession of cocaine. You're also here in 2021 CF 1400AO on charges of possession of cocaine and possession of cannabis. The court has reviewed the charging affidavit as to both cases and found probable cause. As to 1414, going to stay your bonds in amount of $1,000. Oh, sorry. $1,150. And then on 1400, I'm going to stay the bond in amount of $1,150. and $150. Condition of both bonds is you not possess any drugs or alcohol without valid prescription. You are out on release in cases 2020 CF 8494 AO and 2021 MM 32 AO. The court is going to revoke those bonds. We're going to set new bonds in the amount of $0. We're going to appoint the public defender to represent you in this case.
Let me guess. Wait.
Condition of your domestic battery case is that you have no contact with the victim in that case while you're here in the Orange County Jail.
I don't understand this.
Sir, ma'am.
Yeah. Oh, I don't understand.
No contact order still is in place on your DV case. So don't
So I
call,
do
don't
still
contact the
have a
victim from that case, even from the jail. Tell me your name, sir.
Anthony Bernard Parton.
All right, Mr. Parton, you are here in 2021 CF 1387AO on charge of selling and delivery of cocaine. Did find probable cause for your arrest as to that matter. You're going to stay your bonds amount of $7,500. You also here in 2021 CF 1401AO. The court has found probable cause as to the charge of carrying a concealed weapon by a convicted felon. You're going to stay your bonds as to that count in the amount of $5,000. I'm sorry. Condition of your bonds that you not possess any drugs or alcohol without a valid prescription. You possess no weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in your cases. Have a great day, sir.
Yes, sir. Thank you.
Tell me your name,
Honor.
sir. Tell me your name.
My name is Joseph John Pelicano.
Mr. Pelicano, you are here in 2021 CF 1371AO on charge of a sex offender violation and failure to register. Court, the judge signing your warrant did find probable cause for your arrest. I want to set your bond in the amount of $2,000 as to that account. Condition of your bond is that upon your release, if you are released from the custody of the Orange County Jail, that you go to the sheriff's office and register within 24 hours. You are on probation in 2018 CF 15647AO. In that case, the court is going to find an on-view violation based on the warrant that I've read in this case and the probable cause being found. I want to set your bond at $0. Sir, you are a violent felony offender of special concern. You are not entitled to release until your case is resolved as for your violation of probation. I'll appoint the public defender to represent you in this case. Have a great day, sir. Can you tell me your name, sir?
John Petador.
Mr. Petador, you are here in 2021 CF 1395AO on charge of possession of cannabis with intent to sell and deliver. Court reviewed the charging affidavit in this case. I did find probable cause for your arrest. I'm going to stay your bonds in the amount of $1,000. You are out on bond. Condition of your bonds in that case that you not possess any drugs or alcohol without a valid prescription. You are out on bond in 2020 CF 12398AO. In that case, the court is going to revoke your bonds. I'm going to set new bonds at $0. I want to appoint the public defender to represent you in all your cases. You can get in front of that judge to address your bonds on that case. You understand? Have a great day, sir.
Thank you, sir.
All right. Tell me your name, sir.
Thomas Arthur William Pugh, Your Honor.
All right. Mr. Pugh, you're here in 2020 CF 9677AO on a failure to appear warrant. The judge signed that warrant, set your bond at $0. Your bond will remain at $0 in that case. I'm going to appoint the public defender to represent you in this case. Have a great day, sir. Yes, ma'am. Oh, sorry. He was registered?
Oh, no.
Oh, no, I forgot something. All right. Is there an updated phase sheet for this? It was an updated phase sheet for this. Okay, sir, tell me your name.
Travis Paul Sheely.
Mr. Sheely. Okay, yeah. All right, Mr. Shealy, you are here in 2020 CF 13480AO on charge of aggravated battery. Has anybody had contact with the victim in this case?
No, Your Honor.
The judge signing your warrants found probable cause for your arrest. I'm going to set your bonds in an amount of $2,500. Condition of your bonds, you have no contact with the victim. You have no return to the scene of this location. That you possess no weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand that?
Yes, sir.
You are to possess or consume no drugs or alcohol while you're out on release. You understand?
Yes.
All right. I'll appoint a public defender to represent you, sir. Have a great day.
Thank you.
Can you tell me your name, sir?
Don Sumner.
All right. Mr. Sumner, you are here in 2021 CF 1372AO on a charge of sex offender failure to register. The judge signed your warrant, found probable cause for your arrest as to that charge.
What did he say? I don't know.
Sir, I'm going to place you on pretrial release. Condition of your pretrial release is that you report to the sheriff's office within 24 hours of your release from the Orange County Jail and register. Do you understand?
Yes, I've already registered.
When you get released, listen to what I'm telling you.
Oh, I'm
sorry. You need to
sorry.
go to the sheriff's office within 24 hours of your release. Because if you don't show up there, they don't come find you, right? They know where you live. They do checks every month, right?
Yes, sir.
So they know where you are, so they won't come find you if you don't go register. That's the only thing you gotta do while you're on release. Make sure you stay registered.
Yes, sir.
But as soon as you leave here, within 24 hours, with business days, like so if you got release for some reason on Saturday, that you're gonna go on Monday and get it registered, all right?
Yes, sir.
If you don't, you'll violate your pretrial release, you'll be here with me, all right?
No, sir. Thank you.
All right, have a great day.
That was straight pretrial release?
Yes, ma'am.
Thank you.
Tell me your name, sir, ma'am, sorry.
Tanasia Thomas.
All right, Ms. Thomas. You are here in 2021 CT 974AO on charge of driver license suspended. The court reviewed the charging affidavit in that case. I did find probable cause for your arrest. You're also here in 2021 CF 1404 on charge of possession of MDMA or ecstasy and possession of cannabis of less than 20 grams. The court reviewed the charging affidavit in that case and stayed your bond. Found probable cause for your arrest. As to the felony case, the court is going to stay your bond amount of $1,100. As to the driver license suspended case, it's going to stay your bond an amount of $500. Conditions of your bonds is you not possess any drugs or alcohol without a valid prescription, and you not operate a motor vehicle without a valid driver's license. You're out on bond in 2020 MM 594AO. In that case, I'm going to revoke your bonds. I'm going to set new bonds in amount of $1,500 is the count one. $500 is the count two. Conditions of those bonds do not return to the scene of the location where that incident happened. Do not possess any drugs or alcohol. All right. Have a great day, ma'am. Tell me your name, sir.
Edward Bergman.
All right, Mr. Bergman, you are here in 2017 CF 8433AO, charge of violation of probation. The judge signing your warrant set your bond at $0. Your bond remain at $0 as to that charge. I will appoint a public defender to represent you while you're here in our custody. And you can maybe get in front of that judge and modify those bonds. Okay, is Burner? It doesn't look like Cynthia Burner. Yes, ma'am. Yes, sir. Tell me your name, ma'am.
Rachel Mathis.
No, that's not it either. Well, she's here, so. Ms. Mathis, you are here in 2010 CF 47790, sorry, 144790 on a violation of probation warrant. The judge signing your warrant set your bond at $0 in this case. Your bond remain at $0. I'm going to appoint the public defender to represent you in this case. And we can get in front of that judge and they'll talk about your bond conditions. All right, have a great day, ma'am.
Okay.
Pass by Ms. Bruner for a moment.
Yep, I got you. Tell me your name, sir.
Dexter Lawson.
All right, Mr. Lawson, you are here in 2017 CF 8073 AO for charge of violation of probation. The judge signing your warrant in that case set your bond at $0. Your bond will remain at $0 until you can get in front of that judge and they can modify it. I want to appoint the public defender to represent you in this case, and they can get you in front of that judge as soon as they can. All right, have a great day, sir.
Ms. Bruner.
All right, tell me your name, ma'am.
Cynthia Marie Bruner.
Ms. Berner, you are here in 2019 CF 6822 AO on a charge of violation of probation. The judge signing your warrant in that case set your bond at $0. Your bond will remain at $0. I'm going to appoint the public defender to represent you in this case. They can get you in front of that judge to have a bond hearing. Have a great day, ma'am. Tell me your name, sir.
Jose Alejandro Moreno Noboa.
Mr. Moreno Aboa, you are here in 2018 CF 2647 AO for a violation of probation. The judge signing your warrant in that case set your bond at $0. Your bond will remain at $0. I'm going to appoint the public defender to represent you in this case and get you in front of that judge to possibly have a bond hearing.
Okay.
Have a great day, sir. Tell me your name, sir.
Kenyatta Patterson.
Mr. Patterson, you are here in 2018 CF 12770 AO on a charge of violation of probation. The judge signing your warrant in that case set your bond at $0. Your bond will remain at $0. I will appoint the public defender to represent you in this case, and we can get you in front of that judge as soon as possible. Have a great day, sir.
Excuse me, Your Honor.
You can talk to Ms. George if you have a question. Everything you say here is being recorded.
Yes, sir.
All right, sir, don't cover your face. Tell me your name.
Freddie Williams.
All right, Mr. Williams. You are here in 2021 CT 973 AO on a charge of leaving the scene of an accident with property damage. I reviewed that case. The judge, I'm going to stay your bonds. I found probable cause. I'm going to stay your bonds in the amount of $1,000. You're on probation in 2018 CF 15535 AO. And in that case, your bond is set at $0. I want to say your bond is $0 in that case. I'm going to appoint the public defender to represent you in a violation of probation case so they get you in front of the appropriate judge to have a bond hearing. Have a great day, sir. All right, have a great day, sir.
Thank you.
Tell me your name, ma'am. Oh, sorry, Ivan. Sorry. What happens to Ivan Carujo? All right. This is Ivan Carujo. He's here on an out-of-county warrant from Dade County. I don't think we're here for the new cases, so no. I want to appoint a public defender to represent him in those cases. Ms. George, do you want to waive Mr. Carrillo's appearance?
Yes, Your Honor, we'll waive.
Waive his appearance. As to his cases, the judge signing his warrant from Dade County set his bond at $0. His bond will remain at $0 until he can get transported to Miami-Dade County. Sorry. Tell me your name, ma'am.
Cora Kaufman.
All right. Ms. Kaufman, you are here in 2020 CT 2799 AO. You're here for an out-of-county warrant out of Lake County. The judge in that case set your bond at $2,000. Your bond will remain at $2,000. I want to appoint a public defender to represent you while you're here in our custody. Have a great day, ma'am.
Thank you.
Tell me your name, sir.
Jalen DeMarco King.
Mr. King, you are here on a VOP warrant. From Polk County. The judge in that case set your bonds at $0. Your bonds remain at $0 as to that case. I want to appoint a public defender to represent you in the case while you're here in our custody. Have a great day, sir.
So would I be transferred or would I
talk to Ms. George and then before you ask me the question? All right. Polk County's been picking up periodically, but I can't guarantee you when Polk County's going to be here to pick you up.
Yes, sir.
All right. Have a good day, sir. Yep, you too. Have a great day, sir. Can you tell me your name, sir?
Titan Robichaud.
Say your last name again?
Robichaud.
Mr. Robichaud, you are here in 2019 CT 27025. A case out of Brevard County. The judge issuing your warrant in that case set your bond at $500. Your bond will remain at $500 until you get transported to Brevard County or you bond out.
Oh, I'm going to get transported?
You can if you stay here long enough. But if you post bond, then you're going to get a court date.
My bond was $250. It went up?
The warrant, I think when you were arrested, the paperwork said $250, but the actual warrant says $500. So it's a mistake by whoever inputted that.
Is there any way I can get an ROR for this? Because I tried to take care of it.
Wait. I'm going to appoint a public defender to represent you. Tomorrow, myself or Judge Gibson is going to contact your judge in Brevard County, and they were amenable to changing your bond conditions, then they will. If not, you'll be transported to Brevard County probably sometime in the next week. And who is this? I'm on this one.
We're calling Creole interpreter.
She was serious about her picking up patties. Judge Gibson. What happened to him this morning? Almost got it. You went to the fell off?
No. You didn't get a chance to review that paperwork. Oh, it's up to you.
I mean, is there the answer?
She's trying to get through now. We have to use the language line because there's no Creole for this afternoon.
Just set up the system stop and the system.
He said he speaks English.
Speak English, Mr. Bryant? All right, step up. You on the phone? All right, well, let's see. Sir, can you tell me your name first?
La Fortune Mousset.
All right. Is La Fortune your first name or last name?
Last name is La Fortune. First name is Mousset, Musset.
All right. Sir, do you need the services of the Creole interpreter?
I'm good. I'm okay.
All right. All right, Madam Creole, I don't know, Ms. Madam or Sir Creole interpreter, I guess we don't need you right now.
Oh, you don't really need me now?
No, ma'am, we don't need you right
Okay.
now. All right, have a great day.
Thank you. Have a good day. Bye-bye.
Mr. LaForte, you are here in 2018 CF 13979 AO on a violation of probation. The judge in that case set your bond at $0. Your bond will remain at $0 until you can get in front of that judge for a bond hearing. I want to appoint the public defender to represent you in this case. Have a great day, sir.
Yes. Thank you.
Judge, before we go,
Yes, ma'am.
I just need clarification. This morning, the judge called Mr. Roosevelt in still. She only addressed one case. It looks like he has two, so we have to clarify with pretrial services. I'm not sure. Pretrial services. Mr. Hempfield that we called this morning, does he have two different cases?
Yeah, she addressed the cases she needed to. It was the 177.
No, she only addressed one case, and she set the bond to 5,000, 5,000, and 2,500. But it looks like he has another case with the same bond amount.
Like 1775?
Yeah,
She said that.
I ain't heard about it.
But then when she went back, like she was like, oh, those bonds.
Yeah, but she thought that was his case. She only addressed one case. When she addressed the bond, we gonna have to go back and listen to the record, but.
Yeah, or just bring it back tomorrow.
Okay.
I'll be here in the morning.
Both of us, but I stepped on the
Because she was
line.
confused. Remember, she was asking for clarification. And she only
Is there-
addressed
well,
one case.
besides that, do you have anything for the better of the order?
No, that's it. I'll listen to the record.
All right, see y'all tomorrow.